Hello, I'm John Hurd. I've been representing Social Security Disability and SSI claimants for over 30 years, and I'm a named partner in Hurd & Smith. And right now, I would like to address the situation where you receive a notice in the mail that your request for hearing has been dismissed by the administrative law judge. If you're involved in this process, you probably know that when you file your application, it's considered by a state agency, and if it's denied on initial consideration, you seek reconsideration. If you're denied on reconsideration, you request a hearing. That request for hearing is forwarded to the Office of Hearings and Appeals of the Social Security Administration. Every state has one or more of these offices, and they're staffed by administrative law judges, ALJs, that will conduct a hearing in your case. And that's the first opportunity you have to talk to the judge face-to-face and explain why it is that you're not able to do any job for a full-time period of time. So when you file that request, you might have to wait a year before you get your hearing, maybe even more in some parts of the country. And if one day you get in the mail a notice of dismissal, that's very disconcerting because you're probably going to have to start all over again. There is a way to appeal that, but you want to avoid that happening in the first place. So the first thing to know is that when you receive that notice of reconsideration, it is very important that you file your request for a hearing within 60 days from the date of that notice of reconsideration. They allow you an additional 5 days, but I would think of it as only 60 days, and don't get close to that deadline. Appeal as soon as you can. It doesn't cost you anything, and you want to make sure you preserve your right of appeal. Hand deliver it, send it certified mail, whatever it takes to be able to prove that you did request your hearing within that 60-day time frame. After that, you will want to make sure that the hearing office has a good address for you, because if they send you a notice that your hearing is being scheduled and you don't receive the notice and you don't appear at the hearing, they're very likely going to dismiss that case, and you may not find out about it till months later when you check and discover that your case was dismissed. So make sure that Social Security has a good address for you. When you file your request for hearing, be sure that you can prove that you delivered it to the Social Security Administration within the time frame, 60 days after the date of the denial on reconsideration. Now, what happens if you're scheduled for a hearing and the day arrives, your hearing is at 1 o'clock in the afternoon, and you have some emergency, or your car breaks down, or your transportation, if you don't drive yourself, becomes unavailable and you have no way to get to the hearing? So for whatever reason, maybe it's a medical emergency and you're in the hospital or something, you just don't appear at the hearing. Well, you may get a notice to show cause in the mail saying that you have to show a good reason why you didn't appear at the hearing. Don't ignore that notice to show cause. Respond in writing and explain the reason that you couldn't attend the hearing. The likelihood is in that situation, the judge will give you another chance and will reschedule your hearing. And by the way, if you do delay in filing your request for hearing and you're past that 60-day deadline, don't give up. If there's a good reason why you missed that deadline, you can write that up in what is called a good cause request. And the administrative law judge may find that even though you filed on the 67th day or the 75th day even, that you should still be allowed to have your hearing on the basis that you had good cause for late filing of your request for hearing. But the most important thing is, if your case is dismissed, don't give up. Appeal it to the Appeals Council. The Appeals Council of the Social Security Administration reviews unfavorable decisions and dismissals by administrative law judges. And in general, the Appeals Council is very sympathetic and is likely to send the case back for another hearing if your case is dismissed and if you have any sort of reasonable reason that you can give the Appeals Council.
If you have a question or comment about this video, please send us an email to webclients@hurdandsmith.com. We also welcome your questions on Social Security disability. Send us an email and we will reply with an answer. We may even answer your question in a video. For a free consultation with disability specialists who can help determine if you are eligible for Social Security disability benefits, call us today toll-free at 1-877-435-3737. To learn more about Social Security disability benefits, visit hurdandsmith.com to download our no-cost disability guidebook.